I'm Betsy Urbance, and joining me today is Annalise Fierstos, our legal hotline attorney. I'm the general counsel currently for Illinois Realtors, and today we're going to spend a little time with you doing our RELA, as we call it, or RELA, however you want to say it, the Real Estate License Act. That's our own acronym that we made up, isn't it? Catchy? But we're going to do a live session with you. We've gotten some questions in. We thought we'd do kind of an overview of where we are now, the different categories of the statutory provisions, and something about rules that we hope to someday have. And we've gotten some questions in advance. We'll take those up within the context of our presentation. Annalise and I will be switching off. Hopefully you are all, if you're a participant, you are now muted, and you will probably stay that way. So if you wish to ask a question that is not answered in the course of our presentation, you can certainly do that by means of the chat function. And we have really good, able assistant monitoring our chat so that we will get those questions, and assuming we have time. So without further ado, let's just talk about where we are now. The RELA, or RELA, Real Estate License Act, was substantially rewritten, not entirely rewritten, and there's a whole long story that will not bore you with the details here in this session today. But the bottom line is that the substantially rewritten License Act became effective on August 9th, 2019. And there's Annalise. So, okay. So anyway, let's switch back and forth, Annalise. So I don't know who can see what, but you and I can switch back and forth maybe. But then a question that did come in, and a question we all have, and I have to admit that I share these questions with you, is whether and when there will be rules in place that will clarify and help us to administer the newly adopted in August 2019 License Act. I'll tell you that industry, that's us, and IDFPR have some conceptual agreements, and there is a draft of rules out there in the world. Well, it's not in the world yet. It's just a draft of the rules that's going up the food chain at the Division of Real Estate, or the department, or the department for finalization. It also then would need to be approved by the governor. He's a little bit preoccupied. His office is a little preoccupied right now in the wake of all the world events and the state events. But the governor's office has to sign off. Once the governor's office signs off on the draft, they are filed and published for notice and comment. Bottom line on rules, I think we're lucky if we're 6 weeks away from publication. I think we're lucky, but stay tuned and we'll let you know as we get more details on when those rules are published. But we are going to talk a little bit with you today about what our conceptual agreements are with regard to what the rules will look like. So also, I want to say to the brokers that are in their current renewal cycle, and April 30th was the date to renew. Now the deadline has been pushed to September 30th. And I would just suggest to you that if you are a broker licensee that's not a brand new broker licensee, or if you're a brand new broker licensee that got your license in between August 9th, 2019 and November 1, 2019, you need to get either your CE done as soon as possible, or your broker pre-license, which we'll talk about, the 45, or the post-license, excuse me, that you need to get done prior to September 30th. For those brokers that have been brokers a while and all they have are 12 hours of CE to do it as soon as you can. Do not wait till September 30th, because there's a whole bunch of other licensees that will need to renew on that same date. And I promise you that the department will have delays. So that's just a little commercial for getting your CE done if you're a broker. Annalise is going to share with you broad categories that we've kind of come up with on our own as far as how the provisions of both the Real Estate License Act and the rules are divided. So Annalise, you want to share with us those categories?
Yes, thank you, Betsy. And good afternoon, everybody. Thank you again for not only signing on today, but those of you who took the time to send in advanced questions. That helps us a lot to narrow and address things that are of concern in the industry. And as usual, I can see myself now and I'm really close to the screen. But a couple of the things that have come up quite often and that we are going to address are paperless practice and technology. The new RELA rules do take the time, or they are structured in order to focus on an ability to practice in this new virtual world. It's very timely given the last several months and the movement of the industry and all businesses to a lot of remote work. So it's a very timely time for us to be introducing the new law. It works well, and it's and everybody, all of us, are educating ourselves a lot on how to work this way. So we're probably a few steps ahead this time. The other thing that we're going to address is new education and oversight responsibilities that are outlined by the Act. We're addressing teams and advertising, which the new advertising rules, particularly with respect to teams, those have been at the forefront of the hotline questions, and all the way up until the middle of March when a lot of the COVID-related questions started to come in. But teams and advertising have been a consistent concern among the members of Illinois Realtors. Finally, we are going to discuss consumer protection issues and a little bit about the revamp of the recovery fund. Betsy will be discussing that. And then finally, we do have a few catch-all and miscellaneous provisions. That being said, I'm going to turn things back over to Betsy for a moment, and thank you.
Okay, so we're going to address, Annalise gave you the broad categories: paperless practice, education and oversight, teams and advertising, consumer protection. I'm going to say a super little bit about the recovery fund, only that it was prior to the rewrite, it was almost impossible to get to it if someone had been harmed financially by a bad acting broker or a bad acting licensee. And some of those restrictions have disappeared from the Real Estate Licensing Act. So now theoretically, it might be easier to get some relief in a situation, say, where a broker steals a whole bunch of escrow money and there's just literally no recourse for the consumer or even the broker that's been harmed. Sometimes it's brokers. Let's not go down that rabbit hole. But anyway, that's all we were going to really say about that. And we have some other some pressing consumer protection questions that we're going to get to throughout the course of the program. We're going to address these broad categories in order. And Annalise is going to start us off with paperless practice and technology, addressing a question that we did get in prior to the session.
Thank you very much, Betsy. First, just so everybody knows, we took the questions and we broadened a few of those and made them so that they encompass some of the other concerns that were coming in on the hotline as well. But one of the questions that came in was, is there a requirement for branch licenses under the new Real Estate License Act? Not really, not anymore. RELA has been redrafted so that the term branch has been essentially eliminated. Now I say that, but if you get on and you start filling out paperwork on the department's webpage, you will see the term branch used because they just haven't revised all of the verbiage on their webpage yet, but don't let that concern you. Currently, you don't need a separate license for every office. You will have your main office listed with the department, and then you will, in the same application or registration, you will list your other offices, but they will not be called branch offices. Each branch office does have to have an assigned designated managing broker, and one designated managing broker can run more or be in charge of more than one office under their sponsoring broker. If your offices are actually physical offices, you'll still need to comply with all of the old requirements for the physical offices, and that would include having a sign for the office that is required, and records that are maintained You can either keep a physical record, or if you are keeping them in the cloud, you do need to make certain that those are accessible in the event that there is an audit or they're requested by the department. You do need to make sure that they are readily accessible. If you have a physical office, the rule still does exist that that physical office cannot be located within a retail or financial business establishment, and that it has to be clearly separated from any other business within the establishment. So it has to have its own distinct area. So although the term branch has been removed, the requirements for the physical offices do stay in place. I'm going to turn discussion back over to Betsy. Thank you so much.